So if that's all right with everybody, then I will, I think Gareth started recording us now, and he will put everybody else on mute, and I will pass over to him, Mr. Frow. There we go.
Thank you. Bear with me. Right. Good afternoon. Welcome to the first of what's envisaged will be a series of seminars from Regency Chambers about various topics of interest in both family law and associated areas. As today's seminar will be about 20 to 25 minutes long, and as Alison said, there will be an opportunity for questions at the end. For those I may not have met in person, here's just a little bit about my recent experience before joining Regency last October. A remote pupillage was certainly not on my radar, and conducting my first hearings over the telephone is very much learning by doing. I've thoroughly enjoyed the experience, but I do look forward to getting back into a physical courtroom and being able to see people in 3D again. Now, as we all know, the COVID-19 pandemic has changed methods of working in ways that would have been unimaginable before. The justice systems had to adapt practically overnight to a changing landscape, and matters have proceeded in somewhat of a trial and error sense ever since the beginning of lockdown some 10 weeks ago now. Employers have had to react to staff being ill and absent or otherwise furloughed, and working practices have changed immeasurably. However, as we all know, the importance of safeguarding children simply cannot be overlooked or overstated, and we've all had to carry on during the pandemic. There's simply no option for local authorities to simply pause for 3 months and hope everything will be the same when it comes back. So, with this in mind, I'm going to talk today about the Adoption and Children (Coronavirus) Amendment Regulations 2020, very nattily named. These regulations have actually made changes to 10 different statutory instruments, including those dealing with children's homes, private fostering arrangements, and adoption agencies. Today, we'll be focusing, as it says there, on the changes to the Care Planning, Placement and Case Review England regulations from 2010. What these changes mean for us as practitioners, and also what the courts may make of the changes and their effects. So some general information. These came into force on the 24th of April 2020 with very little warning. They were actually laid before Parliament only the previous day. This bypassed a parliamentary convention that a statutory instrument should be laid before Parliament no later than 21 days before coming into force. The rationale for this diminished parliamentary scrutiny said to be the need for urgency. Accompanying the regulations and available alongside them online is an explanatory memorandum detailing, prepared by the Department of Education. In that document, it says that a wait of 21 days would have placed even greater pressure on children's services, struggling under the weight of diminishing staff numbers. I do note here that with lockdown having been introduced on the 23rd of March, the government stated that it had used the intervening month to consult, to undertake a period of consultation in order to understand the impact that the lockdown would have on local authorities to carry on carrying out their duties. That explanatory memo also described the changes, as you'll see there, as prioritising the needs of children whilst relaxing some administrative and procedural obligations to support delivery of children's services, but maintaining appropriate safeguards in such extraordinary circumstances. It's also potentially of note that these changes, or many of these changes, aren't new, and these were first proposed in 2017 in Theresa May's Children and Social Care Bill. At the time, some may remember, there was some strong opposition from MPs, from social workers and from children's rights charities, and the changes then were quietly dropped. It's important to note that these changes, as is said many times in the explanatory memo, these changes are temporary, and unless they are extended, will expire on the 25th of September 2020, which is also the same date that the wider Coronavirus Act also requires parliamentary renewal. The Secretary of State, and it's actually the Secretary of State for Education, must review the effectiveness of the amendments during this 5-month period that they're in effect. However, it doesn't stipulate what format this review should take. The regulations make changes to local authorities in 3 substantial areas, which I've titled Placement of Children, the Placement Plan, and then finally visits and reviews. So turning firstly then to placement of children, Regulation 24 placements initially. Regulation 24 is the provision that covered placement of a child with a relative, family friend, or another connected person on a temporary basis, whilst or until that carer could be approved as a foster carer. You'll see that this regulation has been diluted somewhat. The maximum period of temporary approval has gone up from 16 to 24 weeks. Means that practically it's unlikely to be worry about an interim placement expiring or becoming unlawful during the proceedings, and the full assessment remains outstanding. That's a situation that I'm sure many have come across. Interestingly, it also removes any caveat, if that's the right word, of the person having to have a connection to the child in order to obtain temporary approval. All references to the connected person in respect to the placement of the child are removed, and there isn't a definition anywhere in the regulations as to what a connected person actually is. I referred earlier to the regulations expiring on the 25th of September, unless they were extended. In terms of these Reg 24 carers specifically, any carer approved during the period the regulations are in force, or any person that the local authority has started to approve, will remain an approved carer beyond the 25th of September. I suppose it's a way of ensuring that even if the regulations expire, things sort of carry on, and carers don't suddenly overnight become unapproved. So simply, any person approved during this period will remain so after the expiry, assuming that the local authority remains satisfied that placement with that person for that child remains the most appropriate, then that placement carries on. And whereas previously that person would have needed to have, under these regulations, would have needed to have been a person connected to the child. That's no longer the case. I think important to note is, as with all these changes, which I'll come on to in a bit more detail later on, it is a matter for an individual local authority as to whether it wishes to take advantage of the additional flexibility that the new regulations afford. I mean, ordinarily, of course, it's certainly more likely that a Regulation 24 carer is going to be someone connected to the child, but it is now conceivable that a local authority could use this process to approve a non-connected person as a foster carer. So moving on to emergency placements outside the carer's level of approval, you'll see there. These are placements where, in situations where the child's placed with the carer and the carer has specific terms of approval, and our child, if you like, takes that carer beyond those levels of approval. These levels of approval may be the carer may only be authorised or approved to care for 2 children, and our child may be the 3rd, or they may only be approved to care for teenagers, and our child may be a toddler, for example. Previously, a child, you'll see there, a child could only be placed with a carer outside these terms of approval for a maximum of 6 days. And the local authority had that 6 days to amend the terms of approval. If for any reason they didn't, then after that 6 days, the placement had to end. However, our 2020 regulations have amended the 6-day upper limit and replaced it with a maximum placement length of 24 weeks. The local authority also has the entirety of this 24 weeks to amend the carer's level or terms of approval. Practically, therefore, the practical relevance of this is that a child could be placed in emergency placement for up to 6 months in circumstances where the terms of that carer's approval aren't consistent with this child being placed with them. I think we could all agree that this is a significant, a major amendment on any view. It's major when looked at in isolation, but when viewed alongside the changes to visits and reviews a little bit later on, it arguably becomes even more so. So remember this amendment. So the next amendment is to Regulation 22A of the 2010 regulations, which govern placements with foster carers who are approved prospective adopters for that child. Previously, such a placement could only take place when there was both prior approval of the nominated officer of the local authority and a prepared placement plan prior to the move. I've referred to the nominated officer as the ADM here, but I know they're called different things in different local authorities. So the 2020 regulations have amended 22A to remove any requirement for there to be a placement plan prepared prior to the move. Of course, the placement plan is not the same as the care plan, but the two are often interwoven given the level of information required to be set out in a placement plan, which is listed in a schedule to the 2010 regulations. I think practically, with moves at an interim stage, the local authority should be pressed for a placement plan, and in practice is obviously likely to provide one. However, there is now, under these regulations, no requirement on them to do so before the child is moved. So you'll see there that the power to, or the authority for approving the move is now no longer vested specifically in the nominated officer, but is now widened to encompass the local authority as a whole. The local authority must demonstrate, or must have regard to, and on a practical basis should probably demonstrate, that it's taken into account all the matters that the nominated officer would have considered. You'll see them there, that the placement's most appropriate, that the child's wishes and feelings have been considered, and so on. I think in practice, as this information is, often provided in the form of a social work statement or otherwise, but it is worth sort of keeping an eye on it and making sure it's there, especially if in the event that there's any disputes over the move itself. So now, in terms of placements generally, the placement plan in respect of placements generally. So previously the local authority had 5 working days following a child being placed to provide the placement plan if for any reason, owing to urgency or otherwise, they weren't able to do so before the move. That 5-day period is now replaced by they should provide one as soon as practicable. Now, this will obviously be different from case to case, depending on a whole raft of factors, but again, the local authority should be pushed to provide one in the event that they don't, which I think, is they often do. But because there's now no longer this 5-day period, the definition of what's practicable will obviously be different from case to case. So it may be necessary to nail that down, so to speak. Of course, if necessary, the court can provide one, but it shouldn't. The court can direct one, sorry, but I think obviously it should be easy to agree a period, I'm sure. So similarly to foster to adopt placements, which I spoke about before, again, a decision to move a child, or to place a child in a general placement couldn't be undertaken until there was approval from the nominated officer and this prior preparation of the placement plan. Again, here, the requirement for the placement plan has been removed, although they haven't widened the scope of the decision-making power, and that remains vested solely in the nominated officer. This also includes long-term foster placements under Regulation 22B. Again, it's now as soon as reasonably practicable, whatever that means. So, assessment of a placement this is with a parent or somebody else with PR. Such assessments are governed by or mentioned in Regulation 17 of the 2010 regulations, and Regulation 19 gives a local authority conditional power to place a child before completing that assessment. Basically, where the nominated officer considered it to be necessary and consistent with the child's welfare. But that Regulation 17 assessment still had to be completed within 10 working days. Now, the assessment again must be completed as soon as reasonably practicable. I think, as we know in practice, certainly when we're in proceedings, a Regulation 17 assessment is usually going to be the subject of a court direction. However, for whatever reason, in the lack of one, it's worth keeping in mind that a local authority now has more freedom as to when it provides that Regulation 17 assessment, and a child can be placed without it. I think it's likely that in the event of reasonably practicable becoming a lengthy or comparatively lengthy period of time, the local authority might be asked to justify its interpretation as to what reasonably practicable means, and may need to explain in the event of, for whatever reason, any lengthy delays. So, visits to children in care. The regulations have been amended to allow for such visits to take place by telephone, video link, Skype, / other electronic means. And you'll see the timescales there. The usual timescales for visits are within a week of the placement starting, and then at least 6 weekly thereafter. Now, the 2020 regulations have amended the 6 weekly limit to say that where it's not possible to visit a child within these required timescales, it should take place as soon as practicable thereafter. There's that phrase again. When viewed alongside the fact, as I mentioned earlier, that children can now be placed in an emergency placement for up to 6 months with carers whose terms of approval may not be correct, if that's the right word, to care for that child, I think this extension of the visiting regulations becomes even more stark. Practical relevance, I think, as we've probably all found out to some extent during lockdown, remote attendance isn't always an effective substitute for the real thing. Obviously difficult during any video or Skype call to see home conditions, for example, or to speak to the child alone if it's of an age where that's appropriate. Social work through an advent calendar, that's paraphrasing a recent quote from the president of the family division. He described remote hearings as like looking through an advent calendar, and I think remote visits will obviously be along similar lines. I think, again, I'll point out that it is entirely possible that a local authority may not need to take advantage of these additional, this additional freedom, may be able to carry on completely as normal as they have been doing until now. I think it's entirely possible that local authorities conducting these remote visits may need to more fully, perhaps, demonstrate the nature and extent of that visit, and along with any conclusions they draw from it, they may need to evidence those conclusions. I think from a parent's point of view, a parent, I think, will obviously want to make sure that their child is being visited and is getting what they need. So it may be necessary, depending on the other circumstances of the case, to agree, or for the local authority perhaps to provide a schedule of visits in the event that there's any major sort of dispute or argument on that. So reviews, I've put this in red as it is to some extent probably the most important amendment made under these regulations. There is no longer any requirement for any review to take place after the first 3 months or the second review of the child becoming looked after. First review must still take place within 20 working days of the child coming into becoming looked after, and the second review is to take place within 3 months of that. But the third and subsequent reviews, the third review need no longer be conducted within 6 months of the second, but now only where reasonably practicable thereafter. During obviously a 26-week period, it's conceivable that a child may only have two reviews during proceedings. And again, this sort of dilution, when viewed alongside the changes, some of the changes that I referred to earlier, is something to keep in mind about, you know, the progress of a child through care proceedings and more generally. So therefore, practical relevance, set out some sort of closing conclusions, some of which I've already mentioned. Again, there's the thing there about the schedule for visits and reviews. It may become necessary for a local authority, if it's departing from the usual timetable, to provide that. Parents may need reassurance that their child will be visited now that a telephone call, just a telephone call, if I can put it that way, every 6 weeks is now no longer mandatory. Again, there's the thing about remote visits, any conclusions drawn from remote visits or anything like that may need to be potentially more fully evidenced. And again, I'll keep reinforcing it. The local authorities or everybody should bear in mind that these changes are temporary, and it is a matter for each local authority and the circumstances of it as to whether it needs that greater freedom. I think if taking advantage, if that's the right way to describe it, of this extra freedom, I think local authorities should ensure, or may need to ensure, that the reasons for doing so are fully explained, supported, and again, such changes or departures may need to be supported by, or may need to be supported by more obvious senior management oversight. So I've included here a snapshot of some of the views of what the Department of Education referred to as key stakeholders. You'll see there that it says that these key stakeholders, or certain key stakeholders, were consulted. But then interestingly at the end it says that the Children's Commissioner was informed. The Children's Commissioner, as you see there, said gave her view, and it appears that while she was informed, she wasn't necessarily consulted. The National Youth Advocacy Service expressed some concern, as you'll see there. An Article 39, which is a children's rights charity, issued a letter before action requesting the regulations be withdrawn. I haven't been able to locate an update as to the status of that. And a motion was tabled in Parliament to try and get the regulations annulled. However, that didn't, at the time of speaking, didn't get the required number of signatories. So that concludes this afternoon's seminar. If there are any questions, please do fire away. You should be able to unmute yourselves. Were there any questions at all?
Gareth, it's Toby here. I think most people are still muted.
Yes,
so...
I have unmuted everyone, so everyone now should have the ability to unmute.
Gareth, it's me. I
Hello.
don't know where my video's gone, and I seem to have a small person with me, so the natives are getting restless here. So I think I'll just leave my video off. Go away. You obviously found those quotes in respect of some opinion, but it hasn't been very widely publicised, has it?
No.
There was an article in the Guardian about it, but it hasn't been widely publicised at all.
No, I mean the Guardian article I think mentions the motion being tabled to get them annulled, but no, the changes were rushed through. As I say, they were laid before Parliament on one day, and then they came into force the next day. So yes, there was no or minimal publicity, if that's the right word, or as it seems, consultation on these changes.
And does anybody within the local authorities know whether or not are they being told that these changes are actually happening on the ground, or are people really still trying to do what they should do, I suppose, rather than what this legislation seems to enable them to do?
I'm probably the only person from the local authority on here. It's Rachel Strong from Peterborough City Council. I know that Her Honour Judge Davies has been liaising with our senior lawyer Elaine concerning these changes, but we've given assurances that we're not changing the way we work at present.
Yeah, as I say, you know, it's obviously they're not mandatory changes. There's obviously presumably very much a method whereby you just carry on with the way that things have been up till now, assuming that staffing levels and other other such things allow. But yes, it's not necessarily an enforced change.
I think that certainly if I were to be asked by a local authority, I would say that they need to be very cautious indeed, because whilst these things may be allowed by these temporary provisions, they still have a duty of care to their children,
Of course.
which in fairness most social workers take very acutely. And I don't expect most social workers would take well to the idea that a phone call every 8 or 9 weeks to a child in a previously unregulated placement would do the job. But I think local authorities will be acutely aware that whilst this may be there technically to fall back on, if you plop a child of 3 in a placement for teenagers and something goes wrong, they're going to find themselves on the wrong end of, even if the social worker were happy, which is unlikely, they're going to find themselves on the wrong end of a claim. And I don't think that just a knee-jerk or a knee-jerk reliance on these COVID amendments is going to cut the mustard with a High Court or any other sort of judge. I can see why they did it. I mean, I think that there's a certain amount of jumping up and down from the usual suspects when things happen. But I think that there was a fear that there was going to be a shortage of foster carers.
Yes.
There's one anyway. But foster carers would suddenly say that they couldn't take children because they didn't want children from homes that may have been not terribly clean to start with. And if you were going to catch it from anywhere, it was likely to be this child. So that a lot of foster carers would draw stumps and say, pull up the drawbridge, whatever cliche you want to use. We don't want any children at the moment, thank you. So I think that there was a fear that the number of foster carers was going to fall off a cliff, and probably using foster carers who cared perfectly adequately for 2 children and just who haven't got around to saying, oh, well, can I have 3, was a better option than not having anybody at all. So I can see the justification for some of it. Quite see the justification for being able to plop a child with somebody who's not connected and hasn't really been through any kind of assessment at all. I think that may be a bridge too far.
Yeah.
But as I say, my own suspicion is that nobody will be doing it unless they really have no choice.
I think that's it. I think it will be used, surely, I would imagine, as a kind of last ditch kind of thing, if there is absolutely no other option. I think, I mean, placing a child and a person not known to them for 6 months would appear to be, a little bit of a stretch. But I think they've built in flexibility to give local authorities the choice.
Find your phone.
Whether the local authority chooses to use that flexibility is, of course, entirely up to them.
Have you heard, Rachel, in Peterborough? I mean, we're small anyway, but have you heard that there's been a drop off in foster carers? Has that been an issue, or are we quite fortunate because we're obviously quite a small authority?
I haven't heard that there's any drop off of foster carers. What I did see initially was that some foster carers were very reluctant to engage in having any form of direct contact before all of the sort of remote arrangements got put in place. And they didn't want people coming and going into their houses, even social workers. So it was really necessary for the virtual meetings.
And I don't know whether, Jodie, you want to comment on Lincolnshire, because obviously that, again, hasn't had, as I'm aware, not a huge influx of cases.
No, similarly to what Rachel set out, I think we're still complying with the previous regulations in terms of the visits, in terms of the LAC reviews, the placement plans, because similarly to what Margot set out, you don't want to be getting lazy by utilising the new regulations and then the changes come into effect that you've got to comply with the previous ones, and you just get used to the lapsy-daisy approach, really, as to what is reasonably practicable to be able to do these things, and that's not what we want to be doing in Lincolnshire.
Is that a worry, though, that come September they will just turn around and say, well, this is all right, we'll just carry on doing this? Or do you think there would be too much of a backlash against that?
I don't think there'll be too much of a backlash from Lincolnshire's perspective, because we are still complying with the earlier regulations.
No, but if they said the new ones were going to stay in force because they quite like them.
Well, it depends whether they're made mandatory or not.
Yeah.
It's. I mean, it's possible. I haven't seen anything that would necessarily indicate that they're definitely going to stay in force. But with the fact that some of the changes, not all of them, but some of them have been attempted before.
Which were the ones that were, Gareth, do you know which were the ones that Theresa May was quite keen to shove through? Is that not clear?
They were basically trying to give a local in 2017, and I know that they tried on a number of, a couple of different occasions, and obviously it would have been slightly different each time. But at one stage, they were trying to give local authorities the ability to relieve themselves of some of their responsibilities to children, is putting it mildly. I don't know exactly which ones were proposed each time, but I know that again in the 2017 there was quite a big backlash about it, and Justine Greening just quietly made them go away. So whether they will stay in force, whether when we get nearer to September and COVID potentially will look a little bit different, whether there will be a wider and more publicised debate on it, remains to be seen.
Well, I suspect if the Children's Commissioner gets a bit between her teeth and kicks up enough of a hoo-ha, they won't find it so easy to just extend them, but then we'll be distracted by something else by then.
Very possibly.
A second wave or something.
Very possibly.
Yeah.
Oh,
very interesting.
Yeah. Thank you.
Okay.
Thank you, everybody who joined us, and for those of you watching on YouTube, I hope you had a positive experience.